bullets, annexure A4. My learned friend showed bullets page 105.
Right.
Where he claims to have got the assets. No difficulty. Kindly see the next page. I hereby certify that a true and correct copy of the foregoing has been furnished via US mail on this 21st day of June 2010 to Cryobanks International Inc., care of its registered agent at so-and-so address. So on the date that he purchases the asset, the Muller's notice goes to the company whose assets are purchased. So the company continues to exist. And then Muller's, there is correspondence bullets in the petition itself, starting at PDF bullets 266, where he Muller's says, I need to be permitted to be an assignee. Muller's, if he has a successor in interest, there's no question of him asking me that please.
Have you filed a brief notice submissions?
Muller's, we have in fact.
You have?
Yes, we have. It's on
The
record.
submissions are क्या?
No, it's on record. It was filed on 6/9/2019.
6/9/2019.
The submissions will close it for orders today.
Yes. May I submit my notes? Something,
Yes.
something more. My notes. They see the shareholders transfer agreement, share subscription transfer agreement.
Yes.
Now, if Lordship sees that the share subscription and the license both contains the arbitration and the performance which was to be completed under the share certificate run 100
But
within
is
100
he a
days.
party? Is he a party?
Yes,
Is he a party?
correct. Now, question would be,
But
I'm
he
making
is
it
not
how
a
they are
party.
how they are coming into the party. My lord says, number one, the share subscription agreement has been signed by them. They are admitted it, my lord says, number one. The share subscription.
You have
and
signed the share subscription agreement
Yes.
with
Now,
him.
please.
Not with him, Muller's.
with Life Force International.
With Muller's Cryobanks International Link, which
How
continues
I
to
come
exist
into
today.
my learned colleague will allow me to make my submissions. When I purchase that, I am saying that I am a successor of that, and I'm is demonstrating how I become a successor to it. Now, the successor, my lord, says they are saying that I am 2011, that this particular company is still existing, my lords. Now, number one, the moment this lordship sees the dates and important, which becomes very important. The shares subscription agreement was signed on February 2010, and the lordship will see the performance of the share subscription has to be completed in 180 days. That has been signed by him. Now, in the meantime,
But with whom?
carry on. This is Cryo Bank US. Yes. I'm using the word international.
Now, how do you establish that you have stepped into the shoes, that you are an assignee?
Yes, that's
or a
my
successor in
correct.
interest?
Correct, my lord. I bow down. Now,
Under what provision? You can be an assignee by, say, an amalgamation.
right.
You can be a successor by amalgamation.
Correct.
Or that the entire business and assets have been transferred
Yes.
to you.
Now I'm demonstrating.
Where do you establish that?
Yes, my lord. Now I'm
never
establishing
purchased it as a-
My lords will ask
Yeah, tell us,
yes.
tell us.
At least have some patience, my lord. Now, certificate of title, and then when I say the annexure to this particular certificate of title, I'm acquiring all the rights, which means the documents of that particular company and the documents which contains this agreements and the
Documents. You have to say that you have to acquire the business of the company. You have to be a successor of the company.
two parts.
You can purchase the entirety of the shares of that company.
Correct.
You know, or there is some transaction that, well, there may be an amalgamation, whatever.
I'm quite conscious of a Companies Act and the procedure part is concerned.
Where is there any assignment? There is no assignment at all.
There's no assignment to the effect of which your lordship is saying has to be, but that can be inferred from the conduct, my lord. What is the
You can't infer an arbitration agreement by conduct. You have to first show us
I'm sorry,
that you have taken over the
law which your lordship has read to
the entirety of the business of the US company, that you have taken it over.
Correct. I'm demonstrating this, the business, how they have taken over the business over. I'm demonstrating from the documents itself, my lord.
Show us one document.
Yes, please. Lordship will see why I'm using the word this certificate of service, which they are saying the word John Edward. My lord may find out from this word, page 41, the certificate of service. My learned
Show us
colleague has read.
some document by which you have either purchased their shares, or there's been an amalgamation, there's been a transfer of the entire business and assets to you.
I think these documents are not on record, number one, at the moment. I must say that particular part. But these are the emails, my lordship will find it certain, the documents by which the inference can, if lordship permit me to say, number one, see the emails, how the respondents, they have been interacting with me and also working with the same particular manner is being affirming that to carry forward that particular part. Please, lordship.
We'll look at your submissions and we'll decide the matter. We'll
Yes, my
close it
lordship.
for orders. Huh?
May permit me to, on non-miscellaneous day?
No, we are closing it now for orders. We'll read your submissions.
Please,
You have filed written submissions,
Yes,
right?
They are there
We'll
on
read
the
your
record, and then now I'm giving the judgments. Because those
Circulate them, no problem.
circulating, we are giving it right away, my lord. So yes, those judgments.
Because we
those
are relying
judgments
on
there.
Harishankar Jain, Mullahs, Florida
Yes.
law not pleaded. And Mullahs, the document I
Yes.
showed my lords, whereby after this, on 26 September 2011, the US company buys my shares, is not disputed. The document is not disputed. So therefore, Mullahs, they could not be a successor in interest because that document they don't dispute. They don't dispute that the company continues to exist. How can they be a successor in interest stepping into the shoes? How could they have acquired the entire business? From where did that company pay me $52,479 to purchase?
We'll look at the submission and
25?
we'll take a
It's all in my submissions. I'm so obliged. Well, they only took over assets in execution, not as a going concern. In which case, Birds, that the entity Birds survived and continues in privity with me today.
Yes.
Even today, they are member on my
Now,
members of
can
register.
I, my lord?
Check, is it correct that what you took over were the assets in execution?
No. Yes, that we purchased the assets and execution only.
Then
Number
you-
one.
Then how are you the successor for the purposes of the
Yes.
arbitration clause?
But then the entity doesn't survive. His whole case is on the basis of that.
No, but you are really the purchaser of assets.
I have purchased assets along with all the businesses being concerned. That is what I am showing from the document, my lordship. That if lordship is saying what is been the success and interest, two components. One is,
But have you purchased the business?
yes, that is what I am showing, my lordship.
When do we get that?
Yes, my lords, must permit me these annexure, the emails, my lords. The emails.
Where are the emails?
Yes, emails are, just give me the page numbers. I'm giving the annexure P5, which is at page 57. Give me the PDF page number. Yes. Yes, email. Yes, email. June 24.
Right, come.
June 24, 2010. Because immediately after the sale. Immediately after the sale. Yes. If lordship permit me, I'll show all these documents and emails which continually
All
lordship
right,
will find, yes.
Yes, Annexure P5.
Except,
Hello, Dr. Nerikar.
yes, now, June 25, yes, my lords. Hope all is well. I wanted to make a movement to introduce both of you to each other. Now, both of you to each other. The subject is Mr. Syed Rahil, who has been the certificate of the sale, my lords, is. And then, well, understand movement, introduce
Over the
both of you.
assets of
Mr.
Cryo
Syed Rahil is a principal in the new entity that took over the assets of the Cryo Bank. Then, lordship, next, the payments, my lords, from their own company to us. He is so-and-so, Bilal and so-and-so, we are forwarding the payments of so-and-so, latest by such and such June, such and such, on the board meeting, possibly after so-and-so. Then next, from John Edward, he is the person who was nominated under the share subscription agreement that he will be on the board of the respondent's company, and he is the same gentleman. And when he writes him to the other product, dear Mr. Nelka, thank you for the payment so-and-so, as well as the reimbursement of such and such, desperately need for the payment on so-and-so royalty payments, and the August die and such, and then let me know. Now, I am also scheduled such and such, have a board of directors meeting such and such, and this John Edward, MD, President, Chief Operating Officer of the Life Ports Cryo Bank. Now, there is the business of the Cryo Bank International is now taken over by the Life Force. Now, further emails, my lords, continuously, my lords. Then how they are responding to the officers of the life. Yes, I'm coming one by one. And then it requires
Establish that you have become the successor of the business of Cryobanks International.
yes, now
Your document here.
I don't find the document or to that particular part, but I am showing the document with regard to the exchange of emails and also the successor where the lordship will see all the insurance policies which were there in the name of a Cryo Bank International. They have all had been transferred in the name of Life Force, my lordships. And these documents, lordship will find from these documents. The documents which I will annex by them.
Far-fetched. This
Yes.
is very far-fetched.
There's
Anyway,
a
we'll close
document
it
to
for
the
orders.
contrary
For-
page.
no,
Just see
two
one
parts
page
of it.
61 in the same written
Now,
submissions.
please,
Just see page 61, Mullahs, with me.
If I can, these are the
Straight away,
documents.
Mullahs, just to cut short the controversy, just see page 61.
In the
Email
same-
from them, in the same written submissions of my learned friend, Mullahs. Let me forget everything else. 8th November 2011. This is bullets from them to me, from the petitioner bullets to the respondent.
Yes.
And kindly see, hi, Dr. Mini, and just see bullets, the second last paragraph on the page. In speaking with Mr. Raheel and our board on how
Just
to
one,
assist
page
you in-
342.
Now,
It's 1050 of 1020 of the PDF.
Yes, you got it.
Well, it's just, this is 8 November 2011, after bullets, after the document my learned friend refers to. Well, it's an email by them to me. Just see the last two paragraphs. The last three lines of the penultimate paragraph. We will also need to formalize the partnership between Cryobanks India and Lifeforce Cryobanks by completing the transfer of the previous agreement with Cryobanks International. Well, if they are the successor in interest, they can't seek completion of the transfer. The transfer is not complete,
Okay.
even today.
Anyway, we'll close it.
yes,
for orders.
may I answer, my lords? May I answer, my lords?
We'll read the papers and we'll dig it.
Just give me 1 minute, my lords. Give
We've
me,
been trying to do it for the last 20 minutes, but you have not shown us a single document by which you become the owner of the business of that company.
honors,
Mr. Sibal has been indicating that that company still continues to exist.
It is my shareholder
now,
today.
It's his shareholder. You have to show us one document. We're not going to read all these emails,
all right, I've got it.
Show us, and you told us that you don't have a document.
I am saying that the document which I am showing here is the correspondence and the business document.
Where is the, this is just,
Yeah,
this is
yeah,
absolutely vague correspondence between the parties.
Wait,
Maybe they had an intent to do
which
so.
is this
Where is this formula?
PDF page, my lord. We see if there's not a business relationship, these documents and the respondent would not have acted.
There may have been some business relationship, but does that
The
mean
one
that you become the beneficiary of that arbitration agreement? That's the,
I am, what your lordship is saying, that by proposition is, my lord says, A, pursuant to the sale, which also contains the business as well as the assets. Now, once I have the business interest, I am a successor in interest, and therefore the arbitration, I can understand, your lordship is not, and that particular proposition of law, how I am establishing it, number one, A, there's a documents of the court sale which clearly says the equity shareholdings of that particular company is concerned, number one. Number two, when I see immediately after the sale, the respondents acts with me in consonance, A, because of my relation, A, the business of a cryobank, international, my lord, or otherwise not. Now, how those documents is, we'll see, if they are saying is listed, then lordship will see the subsequent conduct of this 2000 till 2013.
you have said that in
They
your,
are not disputing.
you have said that in your written submissions, right?
They are not so elaborative on that particular, because that was filed in 2018. And now the change in law and the documents.
You have to help yourself if you have to succeed in this matter.
Yes. Therefore, I'm saying that my lord says I can take out and give a 3-page note by next Friday, and these documents I'm showing. Please show the
Next
documents.
Friday is like a different university.
Yes.
You have to do
All
it.
right. Today. Please see. Then give me 10 minutes. By 10 minutes, I will not more than 11th minute. Please see the document of 2013.
Now give us a note by
2013.
Monday. Give us a note by Monday, and we'll not give you just 10 minutes. We'll give you time until Monday. Submit
Right.
your note.
Right. Just
And,
give me one minute. Just see the one document.
Not necessary. You give
All
us
right,
your
all
note
right, all
by
right.
Monday. We'll close it for orders
Right.
and read the note, and then
We'll also
I bow down.
We'll
I
also
bow
give a
down.
note.
I bow down.
arguments can
With
be
the
arguments.
obliged.
Obliged. my lord. Obliged.
Give a note.
Yes.
We have been Malas, severely impacted, but I'll just plus two very short points. Malas,
Who's on the other side?
the state is on the other side because it was the order was passed at their behest. So they are really the other side.
Submission last time.
Yes, but just one second. Mr. Shankar Narayan will allow me.
Yeah.
Malas, what has happened because of that order is that whoever was before the court has gotten the Malas benefit. Now, this was a constitutional challenge before the High Court, where the provisions themselves and the judgment is in rem. So the effect of that today is that whole bunch of us, I'm here for 16, but there are more than 1,000, who have been effectively rendered stateless. They can't be in any state under the state Neet quota. They can only qualify in the 15% of all India. So that's the effect one, Malas. I think that was not brought to the court's notice. Malas, number two, your lordships will have my IAs. There's separate IA volume, I understand, page 362 of that, IA number 22731. Serial number 3 in your
You were not petitioners before the High Court.
Because we were not, because if it's a constitutional challenge, of course, 11,000 students cannot be before the court. Everybody can't be. Because that's why the judgment is in rem. It's not an in personam relief being sought. It's a constitutional challenge. Therefore, for the state to make that offer before your lordships on that basis that, okay, we'll accommodate whoever was before the case was fundamentally wrong. Because look at the impact. Now, what's happening, and I'm going to place that. is I have scores which are 250 marks above those who will benefit under the interim order. 250, 300 marks under each category, general, OBC and SC/ST. Plus that of course can't be the outcome of a court order. That should have been fairly pointed by the.
Now, who are your clients basically?
Plus we are 16 people in this matter who are, my lords, in effect, they were studying. They are all permanent residents of Telangana. Because coaching centers, etc., are better in Andhra, they had gone for studying there for preparing for Neet. But their families are based in Telangana, they are residents of Telangana, they are permanent resident. So last 4 years, they don't qualify because they were preparing for coaching in Andhra. So they are ousted. They can only compete in 15% nationally.
Now, what did the High Court do?
So the High Court read down the rule to say, just like in 2023 August also, the same rule was passed, exact verbatim. The High Court had read down the rule that time also in August of 23. The state chose not to challenge it. So that was the final position. We were, bona fide under the impression that that's the final position. This time, after your lordship's judgment, again the state reintroduces the same rule. They were bound by the High Court judgment having not challenged it. They reintroduced the same rule. The High Court in the impugned judgment again reads it down in the exact same manner following.
What did they read it down basically? What did they say?
What they said was, if you're a permanent resident, or domicile of Telangana, you can be part of the state.
Even if your last 4 years of schooling.
Yeah, that's right. That's correct. So let's look at the incongruity today. They should have fairly pointed all this out to the court. All they said, oh, we'll accommodate 135. Now you please stay the order. Where we have 300 marks more. I'll show cases of 300 marks more. In a NEET exam, 1 mark makes a difference. Also, plus this stay, with all respect, this stay should be vacated and we should be allowed for counseling. Otherwise, very incongruous results are going to be.
The same benefit under the same order should be given to everybody, Milot.
That's right. And this just one more thing. Just the
counseling starts tomorrow. Today started. Yes.
Going on.
1 second.
20th, 20th, you'll just pass the order. 20th of
Just give us a moment.
September. That's the order only on concession by the.
Number 38, right?
It's annexed to all the applications.
In fact, during the course of the hearing, we had specifically raised this issue.
That's right.
What about the students?
Others.
We were also in the courtroom just by chance.
I represent 2 candidates who were not before the High Court. I filed a substantial writ petition here, which is diary number 44665. Exactly like this. We were last 2 years, that is the coaching which they do outside the state of Telangana is being interpreted as they're not permanent resident. Throughout my life, I've studied in Telangana. And last 2 years, I go for higher, it's like Brilliants or Raos or something, just outside on the border. Vijayawada I go, and they have ousted.
Mine is
my
a
writ
similar
is
case. I also went to Vijayawada.
that number is there. But mine is diary number 446.
What we do is, this order was passed by us sitting in a combination of 3.
Yes,
Justice Pardiwala is not available.
That's correct.
Today.
That is
We'll
correct.
keep it on Monday.
Please.
So that if we have to modify the order, we should be in the
Only
same.
one thing is there, that the counseling will begin. So the has begun. So my lords may just say, my lords, the counseling is ending on Sunday evening 6 p.m. So my lords may say that the counseling will not end on that date at least, because then if your lordships were to change anything on Monday, then that can be accommodated in the further counseling. My lords will at least say to that extent.
Lordship may also.
There are other rounds.
The final orders by this court, my lord, we also may be permitted to participate
In the
in the counseling. That
There are
will not make any problem.
My lords, there are 16 rounds of counseling. 16.
It's all meritorious.
This is the first.
Lordship may also call for this, diary number 446.
What we do is, we'll keep this on Monday.
Please, my lord.
So any modification of this
Yeah,
order
that's
should
fair.
be by a bench of 3
Definitely.
judges.
Lordship may just mention
I
this. Diary.
recall this was one concern which we
Yeah.
had.
Lordship had specifically expressed it because we were just standing by in court. We saw it. So your lordship specifically asked that.
But
Yes.
can I make-
We'll keep it on Monday.
Can I make
Lordship may just include these numbers. my lord.
just one submission?
Because, otherwise there'll be meritorious students, more
Absolutely.
meritorious students from
Absolutely.
Telangana
Absolutely.
who will never get these seats.
Absolutely.
Because
That's the
that's
point.
never the intent.
I just want to make one submission.
Extend the.
And many of these students would have gone from Telangana to Vijayawada or to Andhra
The state-
only for some coaching class, etc. They'll be ousted completely. And otherwise they are completely permanent residents of
That's
Telangana.
right.
So very
10th
difficult.
also. They
Very
And
difficult.
many of them are much higher marks in the.
Absolutely.
So if I can just make 2 quick submissions, I know you'll keep it on Monday and whatever decision will come on Monday, but I just want to dispel any notions which might have been planted now. The first is that as far as the students are concerned, we can't make a distinction between those who went to Vijayawada or those who went to Dubai because we have both. So either we go strictly by the norms that we laid down. And the second is this, that the
You
judgment.
said that the last 4 years of schooling should be in Telangana.
Correct. And I say it on the strength, that's why two responses. The first, both for Haryana and for Assam, this court has upheld precisely this requirement, however absurd it may be, has applied its mind and said the state can have, in one of those cases, it's actually 7 years. So 12, 11, 10, 9, 8, 7, 6, till then, you have upheld it. These two separate judgments. That's the first response. So if we had come on day one and we had obtained a stay from this court, even this 135 would not have been allowed. All of them would be out. So that's the first submission. In my view, all of them will be out if there is a stay, and there should be a stay of the judgment.
Give the benefit to whoever was there before the court.
So that's why it was a concession made by Dr. Singhvi after taking instruction. That's the first. The second submission is this, that if you look at the date of the previous judgment that they keep relying on.
All the children staying in your state.
That's
Yes,
right.
Manoj.
No,
All of them.
I'm saying that this is I'm not getting into the emotional side of this.
No, but
Only
then
the
what
law
do you do
says
about them? Yes.
the law says that the previous 4 years have to be in our state because we have several candidates who are good enough for that, who are Telangana, who have not decided to go to greener pastures, who have stuck here, who have done 9th, 10th, 11th, 12th. For better or worse, that's the rule. Now, the second. The second quick point, so that they can be prepared for Monday, is this, that the previous judgment that they keep relying on, delivered by the High Court, which they say we should have gone against, that was clearly in a different dispensation when the AP Reorganization Act's 10 years was going on. That 10 years has come to an end, after which we issued the GO, which now we were permitted to do because the 10-year guillotine had gone up. And we issued that GO only in 2024, July 19th, because the 10-year period had come to an end on 1st June 2024, which is why it's a completely new dispensation.
So according to you, you can validly as a government say that your last 4 years.
Like Haryana and Assam did. We couldn't do it before that date because of a constitutional requirement.
Sunset clauses of the AP reorganization.
Exactly. So now we have a bizarre scenario. In fact, 3 of the applicants who haven't yet opened are those who have registered in Andhra as domiciles there, who are coming here and saying we were writ petitioners here as well. I can understand they registered there because they didn't know what was going to happen in the High Court. All this happened over a 2-3 month period. But correct. So all I'm just completing to say is, therefore, there are people who have gone and registered. There are people who went to court. There are those who didn't go to court at all, who sat on the fence, waited for the outcome.
Once we uphold this requirement of which the High Court has imposed, then
All
it's
out.
not just people who are.
Applicants will go, and everybody the concession was made for will also go.
Because if your lordships uphold the High Court judgment, then everybody.
Not uphold. We are saying set
No,
aside.
set aside.
At our
Set
base.
aside.
At our base.
But the point is that this is not really a prima facie arbitrary criteria. State can always say that you must have certain years of schooling in our state. Now, you can't make a distinction between those who have gone to Maharashtra, those who